Hi, Tim Blankenship here with Divorce661.com. In this episode, we're talking about what happens at a prove-up hearing. It's called a prove-up, P-R-O-V-E, prove-up hearing in a default California divorce. So first, let me answer the question, what is a default? A default simply means that you filed, you served, the other party is not participating or cooperating and not filing a response, and you're going to finalize the divorce on your own. Now, default cases, which are also called true default, because there's also default with agreements, true defaults are probably one of the trickier types of divorce cases in California to get through because they rely completely on California law and California family law procedure and civil code of procedure, as well as, because you're not having an agreement with your spouse, so the courts have to follow the rules of court. What that means is things have to be divided equally. Your petition has to be filed a certain way. You have to indicate the property to be divided in the petition. There's a lot more rules you have to follow with a default. So they're a little bit trickier to get through. They usually, many times, will result in your judgment being rejected. And the reason for this particular episode is I just got off the phone with a gentleman who had his default judgment rejected, and the court said set a prove-up hearing. So what we generally recommend if you're doing a true default, no agreement, no response, is whenever you file your judgment, just file the prove-up form with the court because you'll save yourself some time. If the court has one of two things they can do. If you file your default judgment and you don't file the prove-up form, all they're going to do is reject the judgment and say, set a prove-up hearing. And you're going to waste the 2 months it sat with the court waiting for them to review it. And then you're going to submit it again with the prove-up. And again, you're just going to waste a couple of months' time, however long your particular court's processing time is. So in this particular gentleman's situation, that's exactly what happened. He submitted his default judgment. It was rejected. They said file the prove-up hearing document. He did. He turned back in his judgment. He got a court date, and his question was, what happens at a prove-up? What's going to happen? Do I need an attorney? So here's really what happens. If the court has two options when you submit a default judgment. They can reject it for procedural reasons, saying this was wrong, that was wrong, you didn't list the assets right. I mean, there's a myriad of reasons it can be rejected. But if it's procedurally correct, and the court simply has questions related to generally, let's say alimony request, child support request, or division of assets and debts. And as this guy had no minor children, that's exactly what it was. It's going to be questions related to how he disclosed his community property, if it was disclosed properly, meaning was it truly community? Was it truly separate property? Was it listed properly? Because they want to make sure that the non-responding spouse, for lack of a better word, gets her fair share, even though it's a default. Doesn't mean, and people think this, it's a default, I can take whatever I want. No, the court's going to enforce that the community property be divided equally. And that's a lot of times the downside to a default, because maybe that's not fair. Maybe you want to have maybe it's more fair that you have more of the assets for, a variety of reasons. So defaults, again, last resort. But in this case, for a default hearing, it's going to be talking about alimony. It's maybe talking about your income for verifying that, child support, and generally for division of community property to make sure that's being done fairly. So do you need an attorney? I would say only if you don't feel comfortable speaking in front of the court. But if you've done your entire divorce up to this point to the default all on your own, I think you'll be fine. Go to the default prove up. They're just going to ask a series of questions, and they'll either approve your judgment on the spot, or they'll take it under consideration and approve it later, or they may want you to make changes to your judgment and say resubmit or come back for what they call a hearing on entry of judgment. Tim Blankenship, Divorce661.com. Hope you're having a great day. Talk to you soon.